Okay, good morning, everyone. Thank you so much for joining us for our webinar. We are going to go through estate planning during a crisis. My name is Amy Bryan, and I work for the Riverside Foundation. I'm joined today by Brian Smalls and Walt Zaremba. So I'm going to start off with telling you a little bit about the two of them. Brian is president and CEO of Cornerstone Estate Planners. He is a graduate of the University of Miami School of Law. Brian was a prosecutor and then a criminal defense attorney before transitioning his practice to an estate planning and elder law practice exclusively. Brian lives in Williamsburg with his wife, Sonia, and their two children, Braden and Brielle. Fun fact, Brian played football at the University of Michigan and was teammates with five-time Super Bowl winner, Tom Brady. And I'm not a Patriots fan, but I do think that that is really neat. Walt served his country in the U.S. Army for 33 years, including 2 combat tours to Vietnam. Walt is in his 25th year serving the citizens of York County on their Board of Supervisors and has served as an attorney for 27 years. Most of his time has been dedicated to the practice of estate planning and elder law. So just a few housekeeping things. We will be sending out a recording of this webinar, so look for that later on. And if you have questions during the webinar, please put those in the chat feature, and we'll make sure to get to those questions before we wrap up. So with that, Brian, if you would like to start us off.
Sure, absolutely. First of all, thank you, Amy, for having me today. Truly is an honor and a privilege to get the opportunity to speak on this particular webinar. I also want to say thank you to my good friend and colleague, Walt Zaremba, for participating as well in this particular webinar. So today we're going to talk about estate planning, kind of in general, really basic kind of overview. But obviously, you know, a big part of the reason why we're having this conversation right now is because of the pandemic that has been going on, that has not only impacted not just the United States, but also obviously the rest of the world. And I can't tell you, and I'm sure that Walt will probably agree with this, there have been so many calls, so many people reaching out during this time frame, because the reality is that oftentimes when a crisis hits or there's some type of life-altering, changing event that happens, oftentimes that's when people will think about estate planning. And so to be having this conversation right now, it is important for us to be doing so. And so we've split the presentation up into 2 segments, if you will. And neither of us, I don't think, has any plans on keeping you terribly long today. But the first portion of the presentation we'll talk about the types of documents that you need to have in place while you're still here, while you're alive, okay? And so we'll talk about those documents, and then we'll transition, and Walt's gonna talk about the documents that take effect or that are most useful after an individual has transitioned, after an individual has passed away. And so without further ado, I want to get right into talking about the documents that you will utilize while you are alive. Now, here's the thing. When we talk about estate planning, oftentimes people don't like to talk about estate planning. And one of the reasons why is you think immediately about death. And not only do you think about death, but you think about your death specifically. And oftentimes that keeps people from actually wanting to have the conversation or doing any type of estate planning. The reality is that half of Americans will pass away without having done even a simple will. And oftentimes that can be problematic for a variety of reasons, and we'll get into that. And obviously Walt specifically will talk about that when it comes to wills. But I tell people all the time that when it comes to estate planning is just as much about life as it is about after we transition, after we pass away. And so let's dive right in and let's talk about the documents that we're dealing with when we are alive, okay? So the first document that we're going to talk about is the General Durable Power of Attorney, okay? Now, the General Durable Power of Attorney, most people have heard of the term power of attorney before. And the reality is that there are all types of different powers of attorney, okay? There are powers of attorney that will allow people to sell a car on someone's behalf. There are powers of attorney that will allow someone to enter into a real estate transaction on someone's behalf. But the power of attorney, the general durable power of attorney, is a very specific power of attorney. And of all of the various different types of powers of attorney that deal with finances, the general durable power of attorney is probably one of the most important, if not the most important type of power of attorney that can be put into place when you are executing an estate plan, okay? So first and foremost, the thing that you have to realize and understand when you're talking about a power of attorney is that what you're essentially doing is you're giving power, you are giving authority to someone to speak on your behalf, okay? That person oftentimes is known as the agent. Sometimes that person or individual is known as the attorney in fact. Whatever the term is that is going to be used or utilized, the reality is that person is given a lot of authority under a general durable power of attorney. Essentially, that person, that individual is acting as if they were you. They are they are in a position where they're going to make decisions on your behalf from a financial, from a business standpoint, okay? Oftentimes, powers of attorney, general durable powers of attorney go into effect and people utilize them to conduct banking transactions. Or maybe they need to speak to a mortgage company on an individual's behalf. The general durable power of attorney gives them the authority to be able to do that, okay? Now, something that needs to be pointed out with the general durable power of attorney, there are certain powers of attorney that will kick into effect and they're only durable for, or the duration is for a period of time, okay? The general durable power of attorney is one of the type of power of attorneys that will stay in effect as long as you have that particular power of attorney in effect, okay? It will remain in effect even after you become incapacitated or you're not in a position to be able to handle your affairs and do whatever it is that you need to do from a financial standpoint for yourself. So you need to realize and understand that the document is still going to be in effect if something were to happen to you, okay? Now, another thing to note about it is that the document can go into effect immediately or it can go into effect upon incapacity. Now, let me break that down just a little bit. When we draft general durable powers of attorney, when folks come in and sit down and they make the decision as to who's going to serve as the agent or attorney in fact under the general durable power of attorney, it is important to make the decision about whether it's going to go into effect immediately or after some type of event that renders a person incapacitated. So if the effect is going into place immediately, what that simply means is once the document is drafted and it's been signed off on, at that point in time and at that juncture, that power of attorney, the agent under the power of attorney would have authority to be able to conduct transactions on behalf of whoever the principal is or whoever the individual is that the power of attorney is for, okay? Now, in certain situations, some people say, well, I want to have my power of attorney go into effect only if I become incapacitated or only if I can't speak for myself. That's when I want someone to be in a position to be able to speak on my behalf. Okay, and so oftentimes the question gets asked, well, you know, should I do it immediately or should I do it if I become incapacitated? Now, I always tell people, regardless of whoever it is that you select as your agent, you want to make sure that it's somebody that you trust. Somebody that if you were in a position and you needed assistance, you needed help, you want to make sure that that individual is going to be responsible and is going to be the person that is going to be in a position to be able to handle your affairs in the event something were to happen. So I always tell people that, hey, don't pick somebody that, you feel like you're picking them out of obligation. I'll give you a perfect example in situations where, maybe you have a couple of children. You feel like, well, both of my children need to be serving as my power of attorney if something were to happen. Well, if the situation is that one of your children is not very good when it comes to finances, or they've had issues or trouble in their past that would lead you to believe that they wouldn't be the best candidate to serve as an agent under your power of attorney, then you have no obligation to select them as the agent under your power of attorney. You want to make sure whoever you select, that person, that individual is someone that you trust and is going to do right by your financial, your business situation in the event that they needed to act on your behalf. Okay, so that's important. Don't pick someone just out of obligation. In regards to the document itself, it is revocable, meaning that it can be changed at any point in time. You may decide, that you want to have someone who's really close to you right now serve in the capacity as agent. You may say, hey, I want my spouse to be my agent, and then you can name backups. It may be a situation where you decide at some point down the line that you want to maybe include, another relative or somebody else into your power of attorney situation. And if that is the circumstance, if that ends up being the case, then you can revoke your power of attorney at any point in time, at any juncture, and replace it with a new power of attorney if you elect to do so. Okay. Now, one thing I'll say before we go to the next slide is, it is important to note that your power of attorney, the general durable power of attorney, expires upon your transition or upon your death. Okay. So the authority that is granted under a power of attorney no longer is effective. Okay. You cannot use a power of attorney to conduct transactions on a person's behalf if it is a situation where an individual has transitioned and has died. Okay. And Walt's going to get into, well, what happens after a person passes away. But the power of attorney ceases to have any, give anyone any type of authority in the event that a person passes away. Okay. And we can go to the next slide.
Sorry, having a little issue here.
No worries. Awesome. Okay. So the next thing that we want to talk about isn't necessarily a document, but oftentimes we end up in situations, and I told you at the outset that one of the things that often happens is when an individual does not go through the estate planning process. Again, remember, 50% of Americans are not even doing simple wills. And so what happens in the event that an individual does not go through the estate planning process, does not execute a general durable power of attorney? Okay. Well, what ends up happening is that the courts have to get involved. Okay. And what happens is an individual will have to file a petition for conservatorship. Okay. Now, oftentimes people think that, well, if I'm married, then my spouse is just going to be in a position to be able to handle my affairs for me. And sometimes that is the case. Okay. Sometimes you may be married, you have a spouse, the two of you are on accounts jointly. Then obviously if you're on accounts jointly, then you'll have the authority to be able to have access to the funds in an account. But sometimes you'll have, spouses or individuals that will have accounts that are separate from their spouse. Maybe they have a gift fund, a birthday fund, or something like that. And the only person listed on that particular account to have any type of authority to deal with that particular account is the person that opened up that bank account. Even if the banks know the spouse, they know the individuals, they may even have accounts at that particular financial institution, shared accounts, in fact. The reality is that the banking institution is not going to give them access or authority to get into the account that they are not listed on, okay? And so what happens in a situation like that? Or maybe it's not a spouse. Maybe it's a family member or friend, and they need assistance. They need someone to be able to speak on their behalf, to be able to handle financial affairs for them. Filing a petition for court conservatorship is this step to go. And it's something that we handle on a regular basis. The courts have to get involved. An attorney gets appointed to represent the individual who is oftentimes incapacitated or not competent, not in a position to be able to handle their affairs. And so now you have to go through a court process. And oftentimes when you are dealing with a situation where you're dealing with conservatorship, time is of the essence. There are affairs that need to be taken care of. And so if you end up having to go through the conservatorship process, that could hinder your ability to be able to handle things on behalf of somebody in a timely manner. So that is another factor, or another reason why it's so important to have a power of attorney in place, is because you will have to go through the court process. And God forbid that that process is contested. If you've got two parties who both want to be conservators for an individual, it could end up being a long, protracted situation that is not in anybody's best interest, especially the principal, especially the person who is trying to, or whose situation is deteriorating rapidly. One of the big things about a conservatorship is that where, to do your financial plan, your estate planning, what it costs to do the estate plan oftentimes pales in comparison to what it would cost to engage in litigation, especially if that litigation is contested. It can be a very expensive proposition to have to go through a conservatorship with the courts. Lastly, but certainly not least, you are now faced with a situation where a judge is going to have to make a decision, and not your family members. And oftentimes when people are dealing with conservatorship circumstances, it feels like the family is not empowered because they're not the one ultimately that gets to make the decision as to who is in charge. And you may end up somebody serving in the capacity of conservator who, if you had the decision, that is not the person that you would want to be acting as your agent. So that's why it's important to have a power of attorney in place, because if you don't have a power of attorney in place, you're going to be stuck with conservatorship oftentimes being the only option for you. Okay, Amy, you can change the slides. Awesome. All right, so let's transition and let's talk briefly about healthcare documents. Okay, so when we talked about the general durable power of attorney, we talked about the authority that's given to someone to be able to handle things from a business standpoint or from a financial standpoint. Well, in situations where you're faced with healthcare decisions having to be made, the same circumstances apply. You need to appoint someone. You need to have someone who can speak on your behalf in the event that you are incapacitated and not in a position to be able to speak for yourself, okay? And so there are three different types of documents that we'll touch on very, very briefly. The first document is what's known as an advance directive. Sometimes you'll hear it called a medical power of attorney. All right. These are instructions that are given that are to be followed in a situation where someone has a healthcare crisis. You are appointing an agent to speak on your behalf, to be in a position to be able to talk to doctors, to make medical decisions on your behalf in the event that you're not able to do that yourself. All right. And so In addition to the advance directive, you can also have what's called a living will. All right, now, a living will is a document that can be put into place that deals with end-of-life decisions when you are faced, or when a loved one is faced with a terminal illness diagnosis. And so the living will basically says that, hey, in the event that I end up in a terminal situation, maybe I've been diagnosed that that I'm in a vegetative state, and the prognosis is not that you're going to recover from that particular circumstance. If that is the case, a living will can be very, very effective. And one of the reasons why a living will is so important is that one of the most gut-wrenching decisions that an individual will have to make is that of having to make a determination whether to keep someone on life support or to take them off of life support. And so to put yourself in a position to go ahead and make that decision while you can through a living will, it's very, very important to do so, so that in the event that it ever got to a place and there was a question about what you would want to have happen, the living will can speak on your behalf in the event that you're not in a position to be able to do that. Okay. Now, the living will can also, the aspects of the living will can be included in the advance healthcare directive. Some attorneys elect to have them be all-inclusive. Others will separate the documents. Okay. And that's a decision, obviously, you would make with the attorney that you would work with in order to draft your healthcare documents. Certainly, last but not least, most people are familiar with Hipaa. It's the healthcare laws that prevents healthcare providers from sharing your information with third parties without your consent. Having a HIPAA release sign will allow for whoever it is that you want to be able to gain access to your medical documents, to your medical information, so that an informed decision can be made on your behalf when a healthcare crisis comes about. And so the HIPAA documents will allow for people to gain access to sensitive information that third parties are just that they're not going to turn over to third parties, I should say, just because they may be a relative or a close friend. Okay. All right. So we can transition to the next slide. And so again, similar to the situation where you are dealing with a person who has not executed an advanced healthcare directive. They haven't done a power of attorney. What happens in a situation where the medical power of attorney or advanced healthcare directive has not been put into place? Similar to the financial situation, you now have to file a petition for guardianship. Okay, a guardianship petition will allow for the appointment of an agent, okay, or a legal guardian to be able to make medical decisions on your behalf. It also would include where that person is to reside. So if they need to be in assisted living or nursing home, the person who has who is appointed guardian by the court has the authority to be able to do so. Okay. They will also have the authority to make medical treatment decisions and also end-of-life decisions as well. And so it is important to have the advanced healthcare directive in place, because again, when you go through the guardianship process, again, time is of the essence, and you're oftentimes dealing with circumstances in which you need to be able to act quickly. When you're dealing with the guardianship and when you're dealing with the court, you're at the court's mercy. Now, they try to do their best to expedite the process when it gets in the court. But the reality is that, again, you could have somebody serving in the capacity of an agent and appointed by the court, and it's an individual that you would not normally want to serve in that capacity. And so I've talked briefly about the documents that you want to have in place when you're dealing with folks who are still alive, who are still with us, and decisions need to be made. But what happens after an individual transition? What happens after an individual passes away? Walt's going to take the time to talk about a couple of different documents that will be in effect after you've transitioned. And so, Walt, the floor is yours, my friend.
Well, thank you very much, Brian. First, let me start by thanking Amy, the Riverside Health System, as well as you for allowing me part of this exciting hour or so. It's critical. I normally like to start by saying, notwithstanding we're going to die at some point in time, the most important documents I think everybody should have are the documents that Brian just talked about, okay? Because stuff happens and we're living longer and longer. And unfortunately, often the last couple of years of our life might be a situation where we can't make decisions for our health and our finances. And those powers of attorney that Brian just talked about are critical. Now, whether we like it or not, and regardless of whether or not we become incapacitated, of course, we know we're going to die. But we better start thinking before we pass away, because once we do, it's obviously too late to do much of anything. And as Brian's already alluded to, the fact that approximately 50% of the adult population in this country have done nothing. So often I'm asked the question, well, do I have an estate plan if I've done nothing? And the answer is you absolutely have an estate plan. You will have died intestate when you pass away. Basically, you've done nothing. You haven't done a will, you haven't done a trust. You left it to the statutes of the state that you die in. And so, since we live currently in Virginia, we'll talk about what happens in Virginia. If you die intestate, okay, boy, is that a crapshoot. Because, first of all, when you die owning assets in your name, now, if you own assets jointly with your spouse or somebody else, at the death of the first of you, the assets will immediately revert to the ownership of the survivor. But ultimately, if in a husband-wife situation, at the second death, okay, since the survivor often owns everything in his or her own name, dies intestate, that starts this process called probate. And on average in Virginia, it takes between 12 and 18 months to get a standard estate through the probate process. As Brian mentioned earlier, that's without conflict within the family, okay? Because you can double that time, and we've been involved in a number of cases where often at the death of somebody, all of a sudden there's 2, 3, or 4 law firms involved contesting the estate because the individual died intestate. Right? Now the statutes of Virginia are very clear. It says, first of all, it'll mandate probate. All right? So somebody's got to qualify as your administrator, and that might be the surviving spouse, it might be the son, the daughter, but there's a qualification process. Once qualified, and that's called the personal representative, once qualified, the clerk of the circuit court issues a set of instructions for that administrator to follow, and that involves opening up a file down at the courthouse, a public file that ultimately involves the estate of the decedent. It involves creditors of the decedent. It involves heirs of the decedent. And ultimately, after about 12 to 18 months in a normal size estate, not a very complex estate, that administrator's got to file a report, an accounting, to a player in the system called the Commissioner of Accounts. And those of us who live in the upper Williamsburg area, the Commissioner of Accounts is a very well-known attorney by the name of Tommy Norman. Okay? Not until that office, not his law practice office, but his Commissioner of Accounts office, approves the accounting, is the probate process finally ended, and so forth. So you can see it mandates certain things. First of all, the statutes say, if you are a long-term first marriage, and say you have children, okay? Well, after the probate process, right, the Code of Virginia says the estate's going to go to the surviving spouse if there is one. And if no surviving spouse, it'll go equally to the children, right? Now, notice the costs associated with the probate process. On average, between 4 and 6% of the gross estate of the estate of the decedent will be pulled off as fees as the process unwinds and so forth. So the 2 major reasons that dying intestate, in my opinion, would be the wrong estate plan to have is not only are you putting this burden of probate on the shoulders of likely loved ones you've left behind. But what ends with respect to distribution to the beneficiaries dictated by the Code of Virginia, there's an ability that's lost through this process called asset protection. You know, especially if you have children, for example, who might be prone to find themselves involved with litigation. You had the opportunity when you leave an estate plan, an estate to loved ones, you have an opportunity not only to bypass probate, but also you can leave the assets protected should the beneficiary ever find themselves ensnarled in legal issues, or for that matter, if the once loving relationship between your son and his wife falls apart, goes to divorce, that inheritance may well be part of what goes out with what used to be the loving in-law, who's become the outlaw. I'd like to describe it as such, okay? So again, dying intestate, the two major assets, probate and no asset protection. Now, guess where we're in right now? And this involves both what Brian talked about with respect to the court and probate. Right now, and the courts are shut down. And so guess what's not happening? The probate process mandated by dying intestate is at a standstill. Not real sure when the courts will open. We've heard different dates. So far, the dates have been sliding back further on out, and nothing can be done while the courts are shut as they currently are. So there might be a better way to think about leaving your estate if you have the opportunity while we're alive and well, okay? Because once the curtain comes down, should we become incapacitated, as Brian pointed out, it's too late. Well, of that 50% of the folks who've done something, roughly half of that have done the traditional last will and testament. Real question is, what's the difference? What's the difference between dying intestate and dying with a will? Well, the major difference is we can at least designate beneficiaries, and we designate what we want to leave to those beneficiaries in terms of percentages or specific things that the will identifies that you want to go to a particular son, a particular daughter, or whoever, okay? Does it avoid probate? No. Again, when you die owning assets in your name, second death between husbands and wife likely, it mandates probate. Same process, 12 to 18 months on average, 4 to 6% in terms of the fees associated with the gross estate. And the question really is, why would you want to leave your estate to either dying intestate or dying with a will when the entire process, both cases, when the individual who dies owned the assets in his or her name, mandates probate? And oh, by the way, just like dying intestate, when the assets are finally divided and distributed to the beneficiaries designated by your will, likely there's no protection afforded the beneficiary for things like legal involvement, divorces, and the like. Now, you can provide protection with a will. Your will can actually designate, or rather create, trusts. What's wrong with that picture? Nothing can happen until the probate process is done. And if the will document identifies the creation of a trust or trust, it's always following probate. Again, it may or may not be very satisfactory to you. So the real question is, as we go forward, is there maybe a better estate plan than dying intestate or dying with a will? Right? And in fact, we believe there is. It's called the Revocable Living Trust. Well, what the heck is the advantage of a trust over dying intestate or dying with a will? Well, a couple of very important things. First of all, it will avoid probate if, and I want to emphasize the word if the assets of the trust maker, the person creating the trust, the grantor, the settlor, there are different legal words for that person who creates a trust. We prefer the simple term trust maker. If those assets were sufficiently, and the operative word or buzzword is funded to the trust, in other words, we're changing the way the owner of the assets holds title, the legal word for ownership. When they're funded to the Revocable Living Trust, the trust maker becomes the trustee. And the difference between probate and no probate is when I die as the trustee of my wealth versus dying owning my wealth in my name. We have just defeated this process called probate. We've defeated the 12 to 18 months or longer. We've defeated the costs associated with probate, and we've taken a major burden off the shoulders of our loved ones who likely we have been appointed or we have appointed as our successor trustee to us. Okay? That trust gives us a great opportunity, contrary to dying intestate or dying with a will, to leave the assets that we leave to our loved ones protected from things like civil suits or divorce suits, and maybe even down the road if they ever need long-term care and don't have the benefit of having a long-term care commercial insurance policy, would rather not pay out of pocket for long-term care. There is the elder side of what Brian and I do. We're at estate planning elder law firms. And in a nutshell, and we're not going to get into that today, but it's the ability to be able to protect the assets of the person needing long-term care. And again, the trust allows us to do that because of the way the trust can be structured and so forth. Now, it also identifies beneficiaries and their share of your estate, just like your will will likely do that as well. But again, the major benefit of this revocable living trust over dying intestate or dying with a will is we defeated that annoyance and expensive process called probate, and we can actually leave assets well protected. And that becomes very important if we have a son or a daughter who's somewhat of a spendthrift, somewhat seems to be involved with legal issues. And frankly, I'd like to have my kids, when they receive it, oh, by the way, I have to say this. We really don't owe anybody a dime when we pass away. So again, if they are beneficiaries of our estate plan, that kind of means or implies, we love them. We have worked a lifetime to build whatever we have estate-wise, and we want to leave it to our loved ones. Okay, but again, it doesn't mean we necessarily have to leave it to anybody, given the circumstances of that next generation and the like. The most important persons that are not in this webinar today, okay, and even if we're in Brian's office or Walt's office, the most important persons in developing an estate plan are not the creators of the estate plan. I mean, after all, these are plans. These plans are just hanging around. Having spent 33 years in the military, often faced with a lot of plans. Luckily, we never had to put those plans into action. But the most important people to make sure your will or your trust is followed to completion are your sons and daughters, sisters and brothers that you have designated as the administrator of your intestate estate. Sorry for stumbling on that. The executor of your will or the successor trustee of your trust. Why is that? It's because that's the person or persons that are going to execute the plan. The way we operate, and I suspect that Brian does the same thing, is we always encourage the person who creates the estate plan. The mom, the dad, the son, the daughter, they've created this estate plan. But once we've executed the estate plan, we encourage the creators of the plan to make sure that that most important person for execution, again, the executor of the will, the administrator of the no will situation, or the successor trustee, get them in the office. I call it a tutorial, okay? A tutorial, it's part of our relationship, and we want to make sure that the most important person for execution of the estate plan has a good idea while mom and dad or whoever created the plan are still alive and well, so they can get an idea of what their role is going to be should they become incapacitated, and of course, ultimately when we pass away. Last comment I'll make, and I'll turn it over to Amy for questions, is, geez, let's not forget what we're involved in right now. We're involved with something called COVID-19 or coronavirus. Okay? Guess what's shut down? The court system is shut down. Guess what you can't do? You can't go into court now and petition the court to be appointed the conservator of an estate or the guardian of the estate. You can't go into court and get the process of probate underway. So the neat and smart way to do things that I think, and I think Brian thinks the same way, is not because we're biased, and we are biased because we think that revocable living trust is probably the way to go, but get these documents in place now before something happens, that your own health going south, and on top of all that, now we're faced with this pandemic. And so we are in a situation where having these documents in place before something happens there's probably no more important thing that you can do right now other than surviving this, the COVID-19. So Amy, I'm going to turn it over to you and see if we want to pursue questions and things of that sort.
Yeah, so I have a few questions. You just touched on this, but can you expand more about what options people have to file documents during the current situation? Can you do the living documents now? The only thing you can't do is the will. Can you just expand on that, please?
Yeah, I'll start and then Brian can add on. First of all, the neat thing about if your estate plan is the revocable living trust, guess who or what doesn't get involved? The court system. Unlike dying intestate, unlike dying with a last will and testament, which mandates probate, which puts the court in charge, right? The revocable living trust should never see the inside of a courthouse if, in fact, the assets of the maker of the trust, the trust maker, have been transferred to the trust. Again, we call it funded or funding the assets of the trust. And by the way, our firm has a paralegal who does nothing but, she does all the paperwork for our clients to make sure that the bank accounts, the investment accounts, the life insurance, the IRAs, the 401ks, the thrift savings plans, are all properly funded to the trust. Given the nature of those assets, there's a certain kind of a thing that's done to make sure that they get funded to the trust. So you see, when the maker of the trust ultimately does pass away, but first of all, Brian, you can talk about the incapacity, but when that maker passes away, it's a matter of simply paying the bills associated with the decedent, making sure the final 1040 income tax return is filed with the state and the IRS. And at that point in time, bingo, the distribution takes place consistent with the language of the living trust. So it's incredible how we can avoid the court and the costs associated with that by doing this this document called the Revocable Living Trust, which really has come on as gangbusters. Probably, first of all, let me back up. Wills go back to 1776. They've been with us forever. Okay, we've heard wills from, of course, our dear friends, the British. But the trust has come on gangbusters. Probably, my experience says long about the end of the 1980s, beginning of the 1990s, and just has picked up steam ever since that point in time. Not necessarily for everybody, but again, that's a discussion that takes place in the lawyer's office in terms of what would be the best estate plan to have. Brian, you want to add?
Sure, yeah. So as Walt stated earlier, the courts are extremely limited in what is going on right now. Because of the pandemic, a lot of things that you could normally file with the court, you just can't do right now. They are limiting the activities that are going on in the courts. And again, that's based on a mandate from the Supreme Court of Virginia coming down. And I believe that has been extended. Initially, it was early April. It got pushed back to late April. It was May the 17th. Now it's been pushed back all the way to June the 7th. And so while we're under this emergency order from the Supreme Court, we are extremely limited in what can be done. That being said, if it is deemed or fits a certain criteria, whether it's an emergency type situation, okay, I had one of these type of situations come up during this pandemic where it was an emergency. It dealt with a guardianship, a conservator. situation. It was emergency. It was deemed an emergency because of the COVID pandemic that is going on right now. And so we weren't able to walk into a courtroom like we normally would under the circumstances. We had to have a telephonic hearing. But again, the only reason why we were able to do that is because of the situation and circumstances. That particular individual was in a hospital setting, and they were trying to get him removed from a hospital, and because of everything going on, it was deemed an emergency. So therefore, the court indulged us and allowed us to have a telephonic hearing. Not the most ideal situation. You don't get to present, the evidence in the manner that you normally would when you're dealing with a circumstance like that. But pretty much everything else, you're very, very extremely limited in what can be done with the courts right now. So when it comes to the documents, absolutely, get the documents done that you can get done. Get the powers of attorney done. Get the revocable living trust done. Get the wills done while you can. And so under the circumstances, we are somewhat limited in our ability to be able to do certain things with the court. But when it comes to estate planning and getting documents done, that's not going to stop you, even under the current situations, from being able to execute the documents that will allow you to avoid even have to step foot into a courtroom.
Thank you. The next question is, so one of the things that is really an obstacle to people doing their estate plan is that they think that it's long and complicated. Can you kind of just give an estimate of how long it would take from the first day that you step into one of your offices to get these documents in place?
Yeah, I'll start if it's okay. Well, the most important session would be, let me back up a little bit. Not many years ago, the modus operandi in the estate planning arena was seminars, where people would be invited to seminars and so forth. And a lot of that now is done digitally, through digital marketing and so forth. So somebody gets excited, somehow someone gets excited, husband, wife, or an individual person, and they wind up coming into the office, bullish and early. And normally that first session, the whole point is to make sure that the prospective clients are educated. They share their confidential information with the attorney. The attorney, in fact, in turn shares what the attorney thinks is the best avenue to go down, whether it's a will-based estate plan. Remember, wills become effective when we die, so we need the documents that Brian talked about, or whether or not it's the revocable living trust. When that normally coming out of that first appointment, the client may make a decision right on the spot, may want to think about it. They generally leave that office with a series of papers, a little brochure that sort of summarizes the content of what was discussed. And at some point, the client makes a decision. We'll either communicate to the client to see if there's a decision that's been made, or the client gets right back to us. And so that first appointment, on average in our office, because of its importance, is about 2 hours. Okay, 2 hours. Now, depending on the client's circumstances, I mean, as Brian points out, if there's a medical emergency or a medical issue that because of the diagnoses the prospective client is suffering from, we can turn around in a matter of hours, let's say a day or two, to put everything in place that the client needs. I mean, we don't have a problem. We are not a 8 to 5 organization. We work until we get the job done, and that includes Saturday, that includes Sunday. It also includes in our office, if we have to, we prefer to have the client come into the office because we're very proud of this building that we built back in 2004. But we make house calls. If that client can't get out of the house, we make house calls. And of course, with the COVID-19 pandemic we're in, we make sure that all the social distancing that are available to us takes place before we interact with somebody who might, who knows what, might be diagnosed or might have the symptoms of this ailment or any other ailment for that matter, and the like. Brian?
Yeah, so to kind of piggyback off of what Walt says, everybody's situation is different. If it's your average kind of run of the mill, hey, I just need to have my estate plan done. If that is the case, if that is the situation, it can be done in a relatively short period of time. But one of the things I always impress upon prospective clients when they come in, sometimes that process will be dictated. How quickly we get, like, for example, we may need, certain documents from prospective clients. How quickly can you get us those documents? But Walt said it, what hit the nose on the head, that first initial meeting oftentimes is going to dictate how quickly people need things done. Sometimes, and this happens, I'm sure Walt has had this happen, people will call us and say, hey, I'm about to take a trip. There was a family, they were headed to Paris, and they were like, you know what, I haven't done my estate plan. I'm leaving at the end of the week. Can you at least get me, my powers of attorney done? So in the event something were to happen, someone would be in a position to be able to handle my affairs in the event that I was incapacitated. And so it really just kind of depends on each individual's particular situation. But if it's just a regular run-of-the-mill type situation, I try not to have this situation drag on for months on end. We tell people, hey, come in, we sit down, we have the initial consultation. We want to obviously collect the information that we can from you. Once we got the documents, we generally say no more than 2 weeks, okay? We'll have the documents. We generally try to send a draft of the documents out to them so that they can take a look at it, make sure names are spelled correctly, dates of birth. And if they, want to look through the documents and have any questions about specific provisions, to then provide us with that stuff. And then we can obviously go through that and then obviously have the signing meeting. But as Walt said also, right now with everything going on, we may have to go out to someone's house. I had to go to Newport News recently to go to a house, and yes, I've got my mask, ready, and I will put it into use if I need to, and we'll wear the gloves. If people need to come into the office, we're making sure we're wiping down everything and making sure, again, we're observing the social distancing. So hopefully that answered the question. Everybody's situation is a little bit different, but there are a lot of factors that kind of go into how long it takes to actually get something done.
Okay, thank you. I have one last question, and that is, what is the easiest way to remember your favorite charity as part of your estate plan?
The easiest way to remember your charity? Well,
to include them in your estate plan.
Oh, sure. Well, first of all, your estate planning not only includes ultimate distributions to your loved ones, but if you have a favorite charity, and there are a number of them, I'm sure Riverside's Foundation is one of them, by the way, you want to make sure that your estate planning attorney knows what your intentions are when you pass away. If you want the gift to be made, after you're gone, your estate plan will lay it on out. And it's just a task that you leave to your trustee, if you have a trust, or your executor, if you have a will. And that is if you don't want to make the gifts during lifetime. Gifts, of course, are there's a very big tax advantage making gifts to charitable foundations and so forth. And you'll be thinking about that all the time. But yes, your estate plan is an ideal place to make sure that your wishes after you're gone are fully complied with to whoever you want to leave that gift to, right?
Yeah, so to piggyback off of what Walt said, he's absolutely right. If you have a revocable living trust, your trust document will, you'll talk to your attorney and you will be able to lay out specifically how you want that to happen. You can give gifts while you're still here, while you're alive, and take advantage of, you know, the different things that there are from a tax standpoint in relations to that. So, you know, and there are different ways to be able to give to charities. You know, you may have assets, you know, you accumulated, maybe you have got a retirement fund and maybe you want to give from your retirement fund. Sometimes people elect to take out an insurance policy, life insurance policy, and allow the proceeds of that to go to that particular charity of choice. So it's another way, another vehicle of being in a position to be able to give to your favorite charity. And so that's important to make sure that you express, and that's obviously, you know, I'm certain that when folks come into Walt's office, one of the questions that gets asked is, you know, who do you want to leave your stuff to? Is there a charity that you want to give to? And so, so it's important to go ahead and let the attorney know that that is something that you want to do during the process. And I'll close with you saying this. Estate planning is not a one-time deal, okay? And I know Walt will tell you this as well. Estate planning is an ongoing process. Even after the documents have been signed, it should be a situation where you're reviewing those documents on a fairly regular basis. Here in our office, we will do like an annual checkup. We'll reach out and say, hey, you know, what's going on? Have you acquired a new asset? You know, has a child been birthed, you know, that you want to include now in your estate plan? So just realize and understand, when you create an estate plan, don't think that, you know, I'm done, I don't have to do anything else. It should be a situation where periodically it gets reviewed, so that as life changes happen, that those things get accounted for. And so again, I thank you for affording me the opportunity to participate in this webinar. And thank you, Walt, for you know, doing a great job with this webinar as well.
Likewise, back to you, Brian and Amy.
Absolutely. And thank you for everyone who attended. Again, this was recorded, so we will send out the recording afterwards. I'll also include Brian and Walt's contact information. If you are in need of an estate planning attorney, they're both wonderful and very well respected in this area. So I'll have both of their contact informations there as well. Please respond back to that email if you have additional questions that we did not get to during this presentation. And I will get those to Brian or Walt or both, and get you those answers just as soon as possible. So thank you again. Thank you, Walt. Thank you, Brian. You guys did a great job. And I hope everyone stays safe, and I hope everyone has a great day. Thank you so much.
Thanks, Amy. Thanks so much.
Thank you.
Uh-huh.